here on behalf of the plaintiff.
Sir, your name?
Sorry, Judge. Fellas Lane.
All right, this is the date for non-jury trial, and this is a non-payment of rent case. How much is the plaintiff claim is owing?
The total balance at this time is $3,320.17 plus court costs of $161.
3,000, I'm sorry, 3,000.
$3,320.17.
All right.
Hey, Yana,
Sir, of that amount, is there any that you believe that you owe?
no,
You were going to say something.
I was gonna ask to Jack what he was about to say as far as about the numbers. About saying what I owe, but you already answered the question. I mean, ask me the question.
And
I
Mr.
can break
Finn,
down that amount if you want me to, Your Honor.
pardon?
I can break down the amount if you'd like me to.
Just one moment, we'll get to that. Sir, can I ask you, I received the documents from you. Is there a reason why you don't think you owe that amount?
Buckle up, guys. Today we're stepping into a Michigan courtroom where a simple non-payment of rent claim is about to spiral. The landlord claims $3,320.17 plus costs, and the defendant immediately challenges it, refusing to acknowledge the debt. From the first words, you can feel tension mounting. The stage is set for a showdown between traditional law and unconventional arguments.
Because it's already been paid, Your Honor. Far as reporting adverse information about a co-signer Act 211 of 1989. Panessa Place is trying to held me liable as the co-signer when I have an interest and a signature and I'm a natural person. So they're trying
Okay,
to
so
hold liable.
let me ask you this.
Okay.
Just so that I have the background on it. You reside in this unit that's at, I think 315B
Correct.
at 1000. You reside there.
That's my place of abode.
Well, you live there, right?
Depends on who you're talking about. I'm acting as a consumer. So, far as like I'm there on special appearance, and my estate stays there. But as far as a natural man, I don't have no place. As far as my estate and my
Okay, so when whoever is in this courtroom leaves here to go to what they would call home, where does this person that's sitting here go?
to my place of abode, Your Honor.
Which is where?
a Plymouth place.
Okay.
The defendant introduces a bizarre twist, claiming he's acting on behalf of his estate and not personally responsible for the lease. He refuses to be treated as a co-signer, arguing legal technicalities nobody in the courtroom can follow. As he talks about residence and identity, the judge listens patiently, setting up the clash between courtroom norms and fringe legal theories.
At the 315B.
Correct.
All right. That's what I need to know. Okay. Do you have a ledger?
And I'll give Mr. Lane a copy also.
Thank you.
And Mr. Fantera, this would be your witness, is
Yes.
that correct? Okay, why don't we do this? Why don't we have her and Mr. Lane sworn in, please?
Thank you.
Yeah, one.
Right hand. So swear affirm the testimony you're about to give. God.
I do.
Raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Your Honor, could I give you real quick context on that?
Yes, please.
We had a previous case last summer where Mr. Lane received Sarah funds. And when we had I have a copy, I have a case number, I have a copy of the unsigned copy of the COD. That was entered on September 9th. SOS paid his rent through September, and it left a small balance of, I think about $119, which we waived. So the balance, even though it doesn't show it on there because we didn't actually get the SOS check till sometime later, his rent at the end of September was $0.
Got it.
So the total balance that's on there is 5 months of rent at $513, water and sewer bills, electric bills. There's not even any late fees. And then there's 161 in court costs. So I just want to clarify that, in fact, none of this goes back past September 30th. In fact, I don't know if you remember, we actually, when we had the previous case, Mr. Lane had sued Peninsula Place seeking the return of all money he paid forever. And he denied that he owed money, but simultaneously applied for Sarah, and he denied he applied for Sarah. You verified with probably Aaron at the time that he had applied for Sarah. He ended up getting Sarah funds. He would not sign the COD, and then you basically gave him a choice. I'll enter the COD, or we'll have a trial and I'll give you a judgment. But it sounds like he's raising some of the same stuff now that he attempted to raise.
Your Honor, free to speak.
Go ahead, sir.
So, Your Honor, when I applied for, so first I didn't know what I was applying for. So when I applied for Sarah funding, I ended up giving my principal information, which was my name, my date of birth, and my social security number. Basically, I'm here today saying that I gave
A witness is sworn in, confirming prior payments and clarifying the balance owed. Meanwhile, the defendant digs deeper, claiming he applied for government funds using his personal information, but never received proper consideration. The judge repeatedly asks for clarity, trying to separate fact from the tangled web of sovereign citizen logic, keeping the courtroom on edge.
my principal to Peninsula Place, and I've never received any consideration.
Your Honor, I don't understand what that means.
I again, I don't know what that means. However, are you Trellis Lane? That's a yes or no. Because I'll tell you, if you are, then we'll go ahead with the trial. If you're not Trellis Lane, then I'm going to give them a judgment by default because Trellis Lane hasn't shown.
I'm here on special appearance.
No, you can't do that. You are not an attorney at law because you can't appear for somebody else. So my question is, and I'll ask it again, are you Trellis Lane?
Yes, Your Honor.
Thank you. So, Mr. Lane, October of 2022, did you pay rent to the landlord?
Yes, Your Honor.
Okay, and how did you pay that?
I'm paying with my credits that's on file. So I sent instructions back in May, basically to get my account zero every month.
You do what?
I sent instructions back in May, then I sent another one to December to the CEO.
The CEO of what?
American Campus Communities. Saying it right. So he's seen my email, so he's aware of what's going on. Basically, like I say, I'm looking for consideration. I have not been getting no consideration, no adequate consideration.
Your Honor,
Well, you get adequate consideration for the contract and any payment by virtue of the fact that you have a residence. So I don't think consideration is even an issue.
But Your Honor, I have several questions.
Well, you can go ahead and ask your questions, but I don't know. Let me just ask this. October 2022, how did you pay your rent?
I paid with my took the bill, I endorsed it.
Did you give them cash?
We don't have,
We being whom?
I'm saying, it's a credit system, Your Honor.
So what?
Credit system. We don't.
So who's in charge of this credit system?
You said who's in charge?
Surely.
I mean, we haven't had money since 1933, the American Bacon Act.
We being whom?
As
Who are you talking about when you say we haven't had money? Who is we?
far as like the United States haven't had money since 19.
Oh, they definitely have, and I spent my share. So I don't know. You're saying you gave them credit.
Yes.
In what form did you give them credit in the month of October 2022?
Then credit, I took the bill, which they give me a bill every month, which is a statement. I take the statement. If you want to, I can show you what
Yeah,
I'm doing.
I know what he's referring to. Can I show you?
Yeah.
Well, show him, and then
I got copies for him. Here's what he's getting, Your Honor. We have a third-party billing company called Zigo. And so what they do is every month they bill the utilities. So he gets this bill, and then you'll see at the bottom what he writes is pay to the order of Peninsula Place. And so what he's taken, so for example, the top one says pay to the order of Peninsula Place, $662.12. That amount is his monthly rent plus the $123.12 in utilities that are at the top. There's 3 of these that I've attached. So what he does is he cuts off the bottom and he mails that in as.
Now the debate over October 2022 rent begins in earnest. The defendant insists he paid with credits rather than US dollars, while the landlord's representative presents a standard ledger and billing statements. Every explanation from the defendant stretches credulity, turning what should be a routine inquiry into a test of patience and legal reality for everyone watching.
With instructions to pay to the order of Peninsula Place as if that's a check.
have this marked as plaintiff's exhibit and 2. The ledger being 1. But Mr. Lane, you have a copy of what I've marked as plaintiff's exhibit 2. Is what Mr. Fantera described, is that correct? Is that what you do?
Yes, I'm accepting the credits that's given to me and I'm transferring to that.
Who's giving you this credit? They who?
So Peninsula Place, so in the beginning, when I signed up with Peninsula Place, I gave my principal information. So those payments are supposed to come to me as credit. So
what payments?
The payments that's coming every month. So those payments, they're trying to hold me liable for it, and I'm taking the credits that I'm receiving and dishing it back to them, to Peninsula Place.
Who's giving you credit?
You said who's giving me credit?
Yeah.
I have credit, Your Honor. I have a security interest
In what?
in this so-called contract with Peninsula Place.
Okay. But who's giving you credit? Young man, you keep using these terms, payment, credit, and it seems to me as I'm listening to you that you're using them improperly. So my question is, have you paid anything to the plaintiff in US dollars or anything that evidences US dollars?
No, I haven't paid in US dollars.
Or anything evidencing US dollars? Like a check, credit card, anything like that?
So this is.
No, that's a yes or no.
Can you repeat the question, Your Honor?
Have you,
The sovereign citizen claims hit their peak. The defendant asserts his birth certificate and social security number create a secret line of credit, capable of settling debts. The judge presses repeatedly, "Show us where the landlord can access US dollars." The defendant stumbles, unable to provide proof. This is the point where reality and fantasy collide under the judge's calm scrutiny.
let me just break it apart so we get it real clear. Have you paid for the months of October 2022, November 2022, December 2022, January 2023, or February of 2023, have you paid to anything to Peninsular Place in US dollars?
No, Your Honor.
Have you paid anything to them that is evidence of an account which holds US dollars?
Yes, Your Honor.
What? And what account is it attached to? You better be careful about answering my question. Because if you're telling me that you gave them or paid them something that evidences an account that can access US dollars, show it to me.
You said that's access to US dollars? Right here.
What is that? What Mr. Fantera just gave?
Yes,
How does that access US dollars?
because Your Honor, this account, I'm the holder and I have the interest.
Then show me the balance on that account.
They show you the balance?
Yep.
It shows you the balance.
No, you haven't shown me anything. Show me the balance on the account. If you give somebody something that evidences that they can access US dollars, then there is a balance on that account in terms of what you're giving them. Much as if somebody gave a check to them, they would be able to show the account for which they can then present that check and receive US dollars. Show me that account, Mr. Lane.
Like I said, Your Honor, I don't know what else you're asking for. This is the.
No, you know exactly what I'm asking for.
You're asking for something that's coming out.
Something that evidences that by that piece of paper that you've given them, that they can access US dollars.
Okay. I don't have any other account besides this, Your Honor.
You don't have any what?
I said I don't have any other evidence besides this right here.
That does not show me that they can access US dollars.
Okay.
Where would they take that to, in your mind? Where would they take that to access the United States dollars?
Put it on the ledger.
Where would they take it to access US dollars?
So, okay. So, Your Honor, so I got a question. As far as landlord and tenant relationships, it's sitting here.
I'll try to answer your question as soon as you answer mine.
Okay.
Where would they take it to access US dollars?
They would take it and take the check and put it on a ledger with my credit. Because if I owe something, Your Honor, it would be in a negative balance. How can I pay something that's in a positive balance? How can
You don't have a positive balance.
this is
You have given them a piece of paper that you yourself just said is a check. So where would they take that to access your account
so, Your Honor,
and receive US dollars?
they're acting in dishonor. They're taking it and they never said anything about or object to it. So it was off.
Oh, they're objecting now, certainly. Where would they take it, Mr. Lane?
So where would they take it? I mean, as far as they have a security deposit deposition bond. So they have it in a financial institution.
What financial institution?
Tensions escalate as the defendant claims the payments pulled directly from a trust and even the U.S. Treasury. The judge probes logic, demanding concrete evidence. The defendant flounders, unable to substantiate anything. The courtroom sits in a mix of disbelief and anticipation, witnessing a legal circus that exposes the limitations of outlandish financial theories.
I'm not.
Would they take it to get cash from your check, as you call it, that would then be debited from your account? Where would they take it?
Debited. So what about the credits, Your Honor?
I don't see a credit.
On this paper, it says credit, payments, and credits.
That's not what it means, to the extent it says that. You have no credit. Where would they take it to get US dollars?
So where would they take it? They would take it out of my trust, Your Honor.
Out of your trust.
Yes.
Where is this trust located?
We all have a trust in the
Okay, let's say we all do. I'm not accepting your premise, but let's say we all do. Where is your trust located?
I'm not sure where it's located, Your Honor, but
So if they wanted US dollars for this thing you purport to be a check, you can't tell them where to take it.
in the Treasury,
Which treasury?
the Treasury,
Oh, so they have to go to the US Treasury with this thing that purports to be a check. Really?
they was pulling from the Treasury. That's why they asked for my
Who
information.
is pulling from the treasury?
Peninsula Place, Your Honor.
So Peninsula Place is pulling from the US Treasury.
I got the account attached to my name with my social and my information.
So they're pulling from the US Treasury because of that?
Say that again?
So because of that, they're pulling from the US Treasury?
I mean, they're charging the account. So this account has my information tied into it, which is showing that it's already prepaid. So what they're trying to do is Peninsula is trying to make me repay.
You've never paid anything. So they're not trying to make you repay. They're trying to make you pay.
Your Honor, so how did we get here if I never if I provided my information to Peninsula Place?
We got here because you have never provided them anything
Okay.
to pay on this account in US dollars or anything evidencing US dollars. That's how we're here for 5 months. You haven't done that.
Okay. So in the contract, it says payment and then specify what type of payment.
I'm asking you, have you paid them in US dollars?
No, payment and credit.
But you have no credit.
Your Honor, this is evidence.
Hold on.
Okay.
In order to pay in credit, if you will, you must have something that evidences a balance on that credit. I've already asked you once. Why not? I'll ask you again. Show me something that evidences the credit.
That shows the credit, the birth certificate, and the social security number showing my line of credit that I applied.
So how much is in that line of credit?
You say how much is in the line of credit?
Sure. If you got a line of credit, it's got to have a value. So how much is in it?
I believe everybody has $1 billion.
I didn't ask everybody. I'm asking how much is in your line of credit?
Well, with Peninsula Place, whatever.
No, I'm asking you. You're saying that your birth certificate and the social security, you have a line of credit. I don't believe that to be the case, but what the heck? Let's ask you, how much is then in your line of credit?
Not sure, Your Honor.
So if you're not sure how much is in there, and you give them this thing that evidences, as you're saying, just take this 1 month of $662.12, you don't know if that can be subtracted from that credit you supposedly have.
I'm believing at least $1 billion worth of credit, Your Honor.
Oh, you have $1 billion worth of credit.
We all have credit, Your Honor.
Well, I'm not worried at this point about anybody else's credit. I'm worried about yours. You're saying you have $1 billion, but you have nothing that shows me that you have $1 billion worth of credit. Mr. Lane, plaintiff is claiming that you owe them $3,320.17. Tell me every reason why I should not give them a judgment for that amount.
That's going against the Michigan Consumer Protection Act.
What particular provision are you claiming of the Michigan Consumer Protection Act?
Enter into a consumer transaction in which the consumer waives or purports to waive the right, benefit, or immunity provided by law unless a waiver is clearly stated and the consumer has specified consent to it. I never gave no consent.
What have they asked you to waive?
He said, "Where they asked me to waive my rights
To
as a
what?
consumer."
As a consumer of what?
He said, "A consumer of what?"
Yeah.
Of this Contract,
What rights did they ask you to waive?
my interest.
What interest?
I have an interest in this so-called contract.
Oh, you do. You also have certain obligations under that contract.
So I have obligations.
Oh, yeah,
Okay.
like payment.
Okay. According to, like I said, landlord and tenant relationship, pay the landlord for all the rent arranged under this rental agreement. And that's basically what I have the security deposit for.
No, your security deposit is not under Michigan law for that reason.
What is for, Your Honor? That's what it says, security deposit permissible uses.
And there is no security deposit under this lease. They do not require a security deposit. It's zero.
Okay. Even worse.
Under which
You don't have a security deposit.
Your security deposit is zero. You did not pay a security deposit when you moved in. This client does not require.
you say move in, all this from where?
And even if you had one, the Security Deposit Act, you can't apply it.
Sorry.
So what other reason do you have why you don't owe this money?
And what other reason?
Yeah, you told me Landlord-Tenant Relationship Act, which you haven't pointed to a particular provision. You've talked about a security deposit of which you have none, so that can't be a reason. I don't know, and you haven't pointed to anything under the Landlord-Tenant Relationship Act that would even be applicable in this particular case regarding the monies that you owe. You cited the Michigan Consumer Protection Act. There's been no benefit that they've denied you, no interest that they've denied you. So that can't apply. Give me anything else as to why you don't owe this.
Anything else why I don't owe? I don't understand what else that you're looking for. Like I said,
I want you to tell me every reason why I should not say and give them a judgment for this, the $3,320.17 plus their cost.
so Your Honor, I'm sorry, can you repeat that again?
Which part?
You saying, so how is this not like a contract of adhesion that is more beneficial to Peninsula Place?
I don't know what that meant. Explain what you're trying to say to me.
So it's two parties, and I consider the weaker part. So they wrote this contract and all in the benefit for them. So where did I have any say so in this contract?
Well, you had the big say so of no, you didn't have to sign it.
So ain't that false and misleading? They was never no.
No, it's not false and misleading.
It's supposed
They
to be
didn't.
disclosure.
They didn't force you to sign it. You signed it.
So I'm signing. So is this a loan that I'm getting from Peninsula Place?
No, you are not getting a loan from Peninsula Place.
So,
You are renting an apartment
correct.
in consideration for the use of that apartment, which belongs to Peninsula Place. You're to pay them rent. You haven't for the last 5 months. Actually, you didn't pay it before then because Sarah paid it, but you haven't paid rent for the last 5 months.
Yeah, no, all bills are prepaid.
No, they're not.
Okay.
Your bill is not prepaid.
Like I said, it's in the positive balance. If I owe anything, it will be in the negative.
I don't even know what that means because your positive versus negative is different than anybody else I've ever come across.
You said my positive is.
Yes, right now you're in the negative of about $3,320.17.
Yana, when I log into my portal, it shows a positive balance. I can't owe something in a positive balance. It's just if I log into my app on my mobile device to look at my bank account, it's in a positive balance.
Your bank account.
Yes, this is a positive balance. If I owe anything, it will be.
So you have the money. So you have $3,320.17.
I'm giving an example.
What's giving an example?
If I owe anything, it'll be in the negative.
I don't know what that means. You don't have a credit on this account. You owe them $33.20.17.
If I don't have a credit, Yana, how do they make up an account number with all my information? I had to give them something.
Yeah, you gave them your information. The only thing you haven't done is give them money.
So in other words, you're telling me that I have to repay them, which is already paid.
You've never paid it.
Okay.
No matter how many times you keep saying it, you've never paid it.
Like I said, John,
You've never paid anything since October.
I have federal questions.
You have federal questions. Okay, well, you can take those up where they'll hear those. I don't know what federal questions you have because every state question that you attempted to try to raise falls flat on its face. There's no violation of the Michigan Consumer Protection Act. There's no violation of the Truth in Renting Act. You haven't paid anything. You won't show me an account where that even evidences that you have the money. You haven't paid it.
So this account right here doesn't show my name, Your Honor.
You don't have an account. If you're talking about a financial account, you don't have an account. You haven't shown me one. I've asked you for it. You haven't shown it to me.
Like I said, the account is right here, Your Honor.
That's not your account.
So who account is it? It has my name on it.
You keep calling it an account. It is not an account. You'll have a lot of things that will have your name on them. They aren't your account.
They're tied into with me, and I have an interest.
Okay. You can have an interest. You can have all of that. You have nothing where they could go and get cash. Nothing where they could go and get anything that would even remotely represent payment on this account. And you haven't done so for the last 5 months.
So, Your Honor, on this ledger, it say payments credit.
Look, I'm not going to sit up there and go back and forth with you on that. I've asked you just plain out. Tell me every reason why you don't think you owe this money.
So, Your Honor, I'm a responsible party, and I gave my endorsements. They accepted, and I'm demanding payment. They never gave me pay. Like I said, I have my birth certificate, I have the social security number showing that I am the
Do you
home.
have a bank account?
My bank account? What does the bank account have to do with?
Because that's usually how people pay for their rent.
Your Honor, all I'm doing is enforcing my rights.
I'm not sure which rights you think you're enforcing because I haven't heard one yet. Is there any other reason you believe that you don't owe this $33,2017 that you have not already stated to me?
Any other reason? No, I don't have any other reason besides, like I said, Your Honor, it's already prepaid. And they're trying to make me pay twice, acting in dishonor, accepting and not returning, not saying anything of it. They're not accepting. So they've been taking it ever since I started, maybe March last year?
Ma'am, your name is
It's Jane.
Jane, full name?
Jane Hogan.
Miss Hogan. And what is your position with Peninsula Place?
I'm the property general manager.
Okay. And you would be familiar with the books and ledger regarding this particular unit?
Yes.
You had an opportunity to review that prior to coming to court today.
Yes.
Is it true that $3,320.17 is the balance that's owed on this account?
Yes, ma'am.
Thank you. Sir, is there any other reason why you don't think you owe that money?
The defendant pivots to citing consumer protection and landlord-tenant laws, claiming waived rights and a prepaid account. The judge methodically dismantles each argument, pointing out the absence of evidence and emphasizing consideration and lawful payment. The tension crescendos as the defendant's claims collapse, leaving the courtroom ready for a judgment that seems inevitable.
Oh, yeah.
Because I'm about ready to rule.
Roll, I thought I was supposed to get a jury trial.
No. I set this for trial sometime back in December, actually.
So you waived it for a non-jury trial? Oh,
Sir, you gave no objection nor requested a jury trial. So
yeah, I gave no objection. Okay.
when I set the date on December 23rd, there was no objection to it. And because you had not requested a jury trial at any given point. So I'm not even going to get into that. You waived that right. Any other reason why you don't think you owe the money that's been testified to, sir?
No, Your Honor.
All right. Mr. Pantera, you forego closing argument.
Yes, Your Honor.
All right. Sir, anything else you want to say to the court?
So I have federal questions to appeal a higher court.
Yeah. As soon as I enter my judgment, you'll be able to appeal all you want, if you can perfect it. So the court, having heard the testimony in this case, the court would find that plaintiff has sustained their burden of showing that the defendant owes $3,320.17 in outstanding rent and charges on this account. And the court would order a judgment to the plaintiff in that amount, plus its cost. That would constitute then the redemption amount on this premises. The defendant would have 10 days to pay that, which means he would have to pay that by February 24th, or a writ of restitution or order of eviction may issue. I will sign a judgment.
Should I show it to Mr. Lane?
Show it to him if you'd like, or you can present it to the court. I've issued my judgment.
Okay.
The court has signed that judgment. Thank you.
Before we dive in, buckle up, because this one's wild. We're stepping into the courtroom of Judge Simpson, one of Michigan's sharpest, no-nonsense judges. And today, we've got a defendant who believes the U.S. hasn't had real money since 1933. You heard that right. What starts as a simple non-payment of rent case spirals into a full-blown sovereign citizen showdown, complete with financial theories, legal word salad, and a whole lot of patience from the bench. Let's see how Judge Simpson handles this attempt to rewrite U.S. currency law, right here in his courtroom. And there it is. The gavel comes down, and Judge Simpson makes it official. A judgment in favor of the landlord for just over $3,320. Let's unpack what just happened and why this case is such a textbook example of how not to defend a rent claim. From the start, Trellis Lane's defense was built on a concept we've seen countless times from so-called sovereign citizens. The idea that personal identification, social security numbers, or birth certificates somehow create hidden financial accounts with unlimited credit. In his view, those documents act like secret bank accounts connected to the U.S. Treasury. So by writing "pay to the order of" on his rent statements, he believed he was tapping into that fictional fund to pay his rent. Legally, that's pure fantasy. There's no mechanism in U.S. law that links your social security number or birth certificate to a personal line of credit. When Judge Simpson asked the most basic question, where would the landlord take this to access U.S. dollars? Lane couldn't answer. That's because there is no answer. Courts require actual payment, cash, check, card, or any valid transfer of funds backed by a financial institution. Without that, it's just paper with ink on it. What's remarkable is the judge's restraint here. Many judges might have shut this down earlier, but Judge Simpson gave Lane every opportunity to explain himself, even asking him, multiple times, to show proof of an account, a balance, anything resembling legal tender. Instead, Lane doubled down, arguing that the U.S. hasn't had money since 1933, referencing a common sovereign myth tied to the gold standard and Federal Reserve history. The court, of course, doesn't entertain pseudo-historical theories. It deals in law and fact. This moment also highlights a key legal principle in landlord-tenant law: consideration. The judge pointed out that Lane did receive consideration, the right to live in the property. In return, he was obligated to pay rent in lawful money. That's how contracts work. The idea that one can accept credits or endorse bills as payment has no legal standing because there's no mutual exchange of value. And if you listen closely, you'll hear the turning point, when the judge finally gets Lane to admit he hasn't paid rent in U.S. dollars for 5 straight months. That admission alone sealed the outcome. Everything after that was just noise. Once the judge confirmed the landlord's ledger and testimony, the decision was automatic, a clear breach of contract. Still, it's hard not to notice the irony. The defendant insisted his account had $1 billion in credit while simultaneously facing eviction over $3,320. It's one of those courtroom moments that feels tragic and absurd at the same time. You almost have to admire the confidence. It's just pointed in the wrong direction. Cases like this remind us why understanding real law matters. Judges like Simpson aren't dismissive out of arrogance. They're upholding the basic structure that keeps courts functional. Facts, evidence, and lawful payment, not theories or wordplay, win cases. So, what do you think? Was Judge Simpson too patient with this one, or just giving the defendant every possible chance to make his case? Drop your thoughts in the comments below, because this was one of the wildest landlord-tenant hearings we've seen in a while.
Finally, the judgment is issued. $320.17 owed plus costs. Commentary follows, breaking down the sovereign citizen misconceptions, the imaginary billion-dollar line of credit, and the court's strict adherence to law and evidence. The defendant's arguments failed to hold any weight. This case is a masterclass in why courts rely on facts, not fantasy. Like the video, subscribe to the channel, and we'll see you in the next video.